Welcome, everyone. Give me 1 second. Just hitting go live on Instagram. All right, we are good. Welcome to Notable Approvals. I'm attorney Amanda Schaefer. I've got an exciting case to talk about today and to also talk about some of the changes that are going on with the new administration, what to expect if you yourself are in a similar situation to my client and have to go to USCIS for an interview. Before I get to that, quick reminder, don't forget to like us and follow us on Facebook, YouTube, Instagram, LinkedIn, wherever you are watching. And if you find this video to be helpful or know someone who may, click that share button, that save button, drop us a comment, let us know what you like. All right, let's get to our case. So today's case is about a client who's a native and citizen of Colombia. He resides in Manhattan. He entered the United States long time ago, back in the 1990s, using someone else's visa and passport. And shortly after he entered the US, he actually was wrongfully arrested. And people say wrongfully arrested a lot, and that's not always accurate, but in this case, the cases were actually thrown out by the DAs and the Attorney General, and there was a federal issue as well. Basically, he just got picked up for standing somewhere. So those are non-issues. But, of course, you still have to give the certificates of disposition. After that, they put him into, back then, it was called deportation or exclusion proceedings. There weren't removal proceedings. This was back when the INS existed. And he claimed that he never knew that he was supposed to go to court and didn't go to court, and then got a removal order in absentia, which is when you don't show up to court, and it's not ideal. And he didn't know about it for a long time. In fact, he didn't know until his first wife filed for him, and they told him, we can't grant you a green card because you have a deportation order. So his first wife, things didn't work out. They were married for a while, and he then met his current wife, and they got married back in 2014. They've been living together since before their marriage even. And years later, I think they had tried to reopen his case at times with other attorneys, and it didn't work. And basically, they came to us with, I kid you not, at least 700 pages of documents from the FOIA file, the Freedom of Information Act file, which is what you get when you request from immigration to send you your entire file, because that's how much history there was here. And they wanted to know, is there a point for his new wife to file for him? And they were worried the whole time. And, are they going to be able to get around the fraud issue with his entry and the removal order? So we went through everything, and we basically decided to make a plan, because what the problem is when you don't attend your removal proceedings and you get a removal order, if that occurred on or after April 1st, 1997, when the law changed, then you have to wait outside the US for 5 years before you're going to be eligible for anything. Now, this guy never left the country. There is something called permission to reapply, which people are allowed to file if they have an outstanding removal order, whether in certain cases, even if they haven't left the country yet, but not if you have an in absentia order, because you're supposed to stay outside the country for 5 years. There's no waiver and no exception for it. So that was one of the things we had to look at. Fortunately, he was placed into deportation proceedings before the law took effect, so it didn't apply to him. Otherwise, we may not have done anything to begin with. So we filed the I-130 marriage petition about 2.5 years ago, and then we've just been waiting. And I got to say, I talk about these types of cases all the time, especially, marriage green cards. I've done a lot of them. And this was a case where I felt the clients really had strong evidence. And I'm going to get to some of that evidence in a second. So I was surprised how long it was taking, but I said to them, look, your husband has, or I said to the petitioner, and I was like, there's a removal order. That means they're probably in line for what we call in New York City a Stokes interview. What that means is that's the interview where they separate the spouses. They question one spouse, or the other sits in the waiting room. Then you switch places. They question the other one, and then they bring you back together. And if you guys got any answers wrong, they'll say, I asked you this question. You said A, you said B. Explain the discrepancy. Those are really high stakes, very pressure filled interviews. And you're going to get one of those interviews if you got married after being placed into removal proceedings, or if you don't do well at your first marriage interview. So before that even happens, last year, we get a request for more evidence, which I was like, I don't know. I'm surprised they want more evidence. And again, I will go through the types of evidence we had, but we're like, okay, we'll give them what they want. So I was like, maybe it's just because the petition's 2.5 years old now. But back then it wasn't even that old. But so we submitted a bunch more evidence. And then we got an interview notice. And the clients came in, we practiced, told them what to prepare. And then we got a little nervous because we heard that there were people getting picked up by ICE, Immigration Customs Enforcement, at USCIS at their marriage interviews if they had prior orders of removal. And that's a big concern. And I spoke to other attorneys about it. I confirmed in other offices around the country that in fact was happening. Nobody knew that I spoke to knew of anyone in New York, but I talked to my clients about it and I said, look, these are the risks. You guys got to decide what to do. So one of the reasons I wanted to do this case today is because I know there's a lot of people out there who have prior orders of removal and are trying to get lawful immigration status and are really concerned if they get called in for an interview. Now, this is a decision that has to be made individually on a case-by-case basis. So just because this is what happened with my clients, it doesn't mean that you might not have the same situation and literally walk into Federal Plaza tomorrow and get arrested. I'm not promising that. What I am telling you is talk to your attorney, or if you don't have one, get an attorney in the situation. Highly recommend. But essentially, they were kind of had to choose between a rock and a hard place. Do we not send the beneficiary, the immigrant, to the interview and have him just submit an affidavit, which there's no precedent for, no law for, basically just saying to immigration, hey, we got so much marriage evidence and I don't want to take a risk. Please approve this, which in all likelihood it would get denied. Or do we take the risk that he could get detained and then expeditiously deported because he already has a removal order? He doesn't have a right to see a judge again. And all they have to do is, as long as they have a travel document, put him on a plane. And Colombia started taking back their citizens from the US about a month ago. So there was a lot of stress and we weren't sure what to do. And ultimately I told them that they had to decide. And my client said to me, I've been waiting for so long for this. And, I've at a certain point, you just, got to take your chance. It's like if otherwise I'm never get my green card. And I was like, okay, I'm with you. I'm there for you. I'll do whatever I can to prevent that from happening. So we went to the interview. We sat there for 2+ hours, which, when you're going to USCIS, bring a book. And, everything seemed quiet, but you don't know until you get called in. So we were kind of sitting there this whole time on edge. Finally get called in, and the interview could not have gone any better. I could not have written it up any better. In fact, they did not separate my clients. And it's funny because after all the stress of practicing and everything, I turned to them today about an hour before we got called in. I go, because I try to tell my clients every situation to expect. And I was like, guys, they might not separate you. And they kind of looked at me like, what? And I'm like, well, it doesn't say Stokes interview on the interview notice, which usually does, but that you can't always go by that. I'm like, but we had such strong marriage evidence. I can't imagine them doing that. I was like, I really think you're only here because they're required to call you for an interview because you were in removal proceedings, have a prior order of removal. So we go into the interview, and my clients, this may be the most prepared clients I've ever had. I am not joking when I say this big the binder was. So we're talking, I don't know, that half a foot, more than half a foot, 10 inches high, like gigantic. It was a binder of all of their good faith marriage evidence. And we get in there, and the officer looks at it, and she's like, oh. And I was like, and she's like, yes, it's very organized. And I joked with the officer. I was like, I told my clients to make it easy for you. And she's like, they did. She's like, I really appreciate this. So if you watch any of my videos where I talk about how to prepare evidence and whatnot, there's a good reason. When you make people's lives easier, good things come of it. So we get in there, and she, asked them for their updated evidence, their identity documents, and then says to the beneficiary, he did have a couple arrests, but they were all not even pleas or dropped. They were like dismissed on motion of the DA because there wasn't enough evidence to move past that stage. Because again, I do believe my client that this was not, the arrest shouldn't have taken place to begin with. They asked him if he had a prior removal order. He said yes. He's like, well, it was a little confusing because she's like, when did you attend court last? And he's like, I never attended court, because he didn't know about the hearing. But he knew, like I said, found out about the removal order later on. And then she said, and this was very refreshing from a USCIS officer, I'm going to be blunt, because I like when people are upfront with me. You guys are not here because we are doubting the good faith marriage. You had plenty of bona fides. You're here because he has a prior removal order and we had to call you in. And we're like, okay. And she's like, so you guys are good to go. And that was it. That was the interview. We sat there for 2 hours to be in there for 5 minutes. I'm so happy for these clients because I knew they had a real marriage. I knew it was going to get approved. It was just the stress of, will he get arrested? And basically, their whole lives would change. And we safely got out of the building, no arrest, no mention of ICE, nice, calm and quiet there. So the next steps that we have for them is we're going to have to file what's called an I-212, which is the permission to reapply, and the I-601, which is the fraud waiver. Then we'll be able to file for adjustment of status. So they still have a long route to go. So that's why I'm primarily talking about this case, to highlight the fact that if you do have a prior removal order, there is a risk you can get arrested at your USCIS interview. I have heard of it happening in other offices around the country. New York City, so far, I've not heard it happening, but it doesn't mean it can't or has not. You have to make that decision yourself. It's not easy. Bring a lawyer, consult a lawyer. If you need one, our contact information is scrolling across the bottom of your screen. And, I'll give some updates on this case, in the future as they come, hopefully only good news. So the last thing we'll do is take a quick look at all this evidence. Why did the USCIS officer feel it was so strong that they didn't need to even question them? Well, obviously, length of the marriage does matter. They have been married for over 10 years, but it's not dispositive. They don't have any children together. But we had detailed affidavits that they both wrote explaining, because we started the fraud waiver already too, so it was kind of talking about the hardship, but also talking about how their relationship was real. We had a joint rental agreement for their apartment. We submitted over 9 years with the initial filing, and then another 3 years with the response to the request for evidence, or RFE, along with some of the rent checks. They've been filing joint taxes since 2014. We submitted every year. They've had joint bank accounts since 2014. I told them we don't need every month. We submitted, I think, 2 a year until the more recent years and submitted more than that. They had joint Con Ed bills for a number of years, joint car insurance, joint health insurance, employment benefits listing the other spouse's beneficiary, retirement and pension benefits listing the other spouse's beneficiary, joint credit cards, joint cell phone bills, evidence that they attend medical appointments together, Christmas cards sent to both of them from family and friends, 7 affidavits from family and friends, and of course, photographs of them at the wedding and on different trips and whatnot. I just rattled off a lot of evidence. And in fact, if you look at the list of evidence I give to clients when we tell them what type of marriage evidence will show that they have a real marriage, I probably listed 75% of what's on that list. A lot of joint financial evidence, a lot of good evidence. And again, I can't emphasize, it's hard for me on this camera, but you get the point. It was a gigantic folder. So what this case shows us also is that even if you have a prior removal order or you're in removal proceedings and have to go through the Stokes interview, that it's not always so bad. If you have a real marriage, it's not bad at all. If you submit good joint financial evidence, good bona fide evidence, it's not going to be that bad, and maybe they won't even split you up. You always prepare for the worst. So I separated the clients during practice, and I drilled them on all these questions. So they were completely ready to go, whatever the scenario was, and luckily they didn't have to worry. So that is really all for today. Like I said, it was a long, long day, but in the end, I'm glad everything worked out because last night was a pretty sleepless night for me. I've never had a client get arrested at an interview like that, and I really hope to never have to go through that experience with a client. So if you need an attorney, like I said, contact information scrolling across the bottom of your screen. Don't forget to like us, follow us on Facebook, YouTube, Instagram, wherever you are watching. And if you find this video to be helpful or know someone who may, please go ahead and hit that share button, that save button. It looks like I muted myself again. I hopefully not the whole time. This mic, if you tap it, it mutes you. But anyways, thank you all for watching and have a good day.